otherwise minded to uphold their decision, we of course don't actually need to go to the notice at all. I
Well,
understand.
we're not in the position to tell you that at this.
We're not in the position to do in the context of an appeal. I mean, the most we could do, it seems to me, would be to send it back to the tribunal.
And my lord, the reason for raising, all I would seek to do, if I was able to see that you had jurisdiction, is to give an indication that the tribunal had failed to ask the more additional question that we have identified in our supplemental scouts, in saying that they've looked at it, the question of valuing benefits from the wrong end of the telescope.
See, now there might be thought to be two possibilities. Either you're saying that the tribunal arrived at an impossible conclusion on the facts, but I'm not sure you're really saying that.
I'm not.
So it has to be, does it, that they have misinterpreted 43(7)(b, because on the correct construction of that as a matter of law, them to take the view that this was not a relevant matter, or meaning that it was impossible. Well, I mean, they're entitled to take into account anything they think is relevant, subject to certain limitations. So, were they obliged to treat this as relevant, or what?
Well, I think they have purported to I think they have suggested that it is potentially relevant.
They have said it's relevant, but they have said, and the reason it's neutral is that taking 507 and 508 together, they can't say that
It is so obviously unreasonably high that it cannot reflect a proper valuation of the rental business's benefit. The question is whether, when they have only been able to obtain the benefit by creating the joint venture as their creature, we've indicated, if it is not a price that they would have been able to achieve otherwise, it doesn't reflect in any way an objective valuation, then they've received the benefit.
So, in dealing with the appeal, you say, well, you can take a broad view of what's a benefit, and you're not tied to the text if this criterion is satisfied.
What they've possibly appropriate valuations, and we say the question is on the balance of.
I understand it was more than they could have got if they tried to sell the business to some independent third party.
Yes.
Now, and if the poor bundle, it seems to me that essentially what you're asking us to do is to say that the tribunal was wrong
in not finding that it was an overvalue in the way that you've described in your respondent's notice, and also in failing perhaps to take on board that there was this, which is a point you've already addressed this on, there was this sort of benefit in the sense that they got more than Lazards thought they were going to get. Well, now, never mind about, I mean, we can obviously, but we're not going to have a look at what Lazard said. Straightforward.
which bit are we looking at? So
we would welcome the indication that the question that was asked.
Yeah, but I may take that on ourselves. I think theoretically it would be open us to set